So, as I understand it, civil rights groups were sort of hoping that this could be a test case that would then allow them to, go after some of the other more restrictive laws that we've seen put in place since before the last federal election. Is the conclusion here very specific to Arizona or very specific to these two laws, or will it have implications beyond Arizona and across the country?
Yes, yes, and yes. So the case here obviously deals with the two laws in Arizona. But as you said, this case was watched because we're talking about a federal law, and when these state laws, when state voting laws will violate this federal law, which Justice Kagan in dissent says this federal law, the Voting Rights Act, it represents the best and worst of American democracy, meaning it's the best of us because we want to protect everybody's equal access to vote. And it's the worst of us because let's talk about why we needed this law in the first place. Now, to answer your question, yes, people throughout the country on both sides of the voting rights debate have been watching this because it tells us how strong the Voting Rights Act will be when we're thinking of challenging all of these restrictive voting laws and voting bills that are pending throughout the nation. And so what Chief Justice John Roberts did, in my estimation, in my fairly quick reading of this opinion, which is 85 pages with both the majority and the dissent, is that he has not made Section 2 particularly robust in terms of protecting voting rights. He made it a bit more of a balancing test. He said, we really always have to tolerate the, quote, usual burdens of voting. One of the usual burdens of voting, he says, is that we have to figure out on election day where your precinct is and you have to travel there. One of the usual burdens of voting is that if there are people who can drop off your ballot, you have to know who those people are. And he gave a lot of weight, I think, to the state's argument here, saying that they needed to be able to decide where to put their polling places, that they needed to protect the integrity of the vote, and that's why they could only have a few people return those ballots. And so I think what we see from the Chief Justice and the majority is, in my mind, kind of saying, look, the burden isn't that great. You still have equal access to vote. And then talking about how important the state's interests are. The Chief Justice also considered this idea. He said, we also have to look, is there a disparate impact on racial minorities? And he didn't find that in either of these two laws. We have a completely different view of the exact same two laws in the dissent here. Justice Kagan is looking at this and basically saying, Chief Justice John Roberts, you see an apple. How do you see an apple? Clearly, it's an orange. It's really startling what a different view she has of this case. And she says, obviously, this has a disparate impact on minorities, and that Section 2 of the Voting Rights Act doesn't fulfill its promise of acting to protect the votes, particularly of racial minorities. So this is a long way of saying for people who wanted to challenge restrictive voting laws throughout the country, they cannot be excited about this ruling. It's not a good ruling for them.
You may have already mentioned this, but the split was 6-3. Any surprises in, who ended up on which side of the decision?
I think the surprise in a weird way is that we haven't seen more of these 6-3 conservative to liberal splits. And it's interesting that the last two cases of the term were two cases dealing with elections and the political process, two cases where we did see that predictable 6-3 split. You and I've been honored to be able to talk about other Supreme Court cases that have been coming out throughout the end of the term with you. And a couple of times you've said to me, Jessica, are you surprised by this split? And we've talked about why it's not that typical 6-3 split, or, wow, this is a unanimous decision. It seems so contentious, or this is 5-4 and it's kind of a strange alignment. Where you tend to see what we predict, that, quote unquote, conservatives on one side and then liberals on the other side, which cases bring that split out maybe more than any other case, It's the voting rights cases, it's the political process cases, it's the election law cases. It's the two cases that we saw this morning. So fairly predictable. The surprise would have been a break on either side, which is what we didn't see.
All right, let's talk about the other key case from today. A narrow 5-4 decision. The High Court ruled to strike down California's donor disclosure law. What's at the heart of this case, and what do you make of the decision?
So this case really deals with a California law where they say to major donors, you have to give the California Attorney General some information about you if you are a major donor to a charity, because what the state says is we want to make sure that there is no fraud or abuse of the charitable form of nonprofits. And what the court said is, California, that's not actually what this is about, right? This is really about administrative ease. You don't usually use this information to, for instance, prosecute fraud or prosecute abuse. What you use this information for is just being able to have easy access to this information. And so this case really boiled down to is the state's interest important enough to force these major donors to provide this information to the California Attorney General? And what the court said here is no, that the California cannot require that major donors to nonprofits provide this information to the Attorney General. But the more important part is that the court really made the standard here for disclosure laws, I think, a much higher standard. And so that means if we're looking at campaign disclosure laws, if we're looking at laws where you say to somebody, tell us who your contributors are, tell us how much money you're spending either to a candidate or a political party or a political action committee, that the court really made the standard by which we review those disclosure laws a lot higher, which is another way of saying, I think it called into question the continued validity of campaign disclosure laws, arguably throughout the nation. That's not good, in my opinion, for a system that we have after Citizens United, where we have virtually unlimited money. But the court said in Citizens United, don't worry, we'll have disclosure. After today, the question is, will we still have disclosure?